Number 61, MAK Technology Holdings versus Anyvision Interactive Technologies.
Good afternoon. May it please the Court, Leonard Lesser for the appellant Anyvision. Your Honor, I would respectfully request 2 minutes for rebuttal.
Yes.
In its divided ruling, the First Department panel in this case violated a fundamental principle of contract interpretation by failing to give effect to a defined term in the parties' agreement. Here, the parties deliberately used capitalized defined terminology as distinguished
Does it
from
matter here that you
non-capitalized defined
have
terms.
a 3211 motion?
I'm sorry, Your Honor.
Does it matter the posture of the case that was before the court? It's a 3211. So you have to conclusively demonstrate, as a matter of law, that your position is the right one.
And this is a 3211A1. So what we did is we presented the court with the parties' agreements, with their clear, unmistakable terms, as well as the corresponding documentation, and that's the posture that the court ruled on.
And that the intent is clear and that there's no other interpretation.
Not with respect to the terminology at issue in this case. Article 8 will go back to the referral agreement.
But you do admit there was typographical errors here.
Yeah, there's a typographical error, but as this court has repeatedly admonished, a typographical error.
Excuse me a second.
Yeah.
How do we know that the typographical error does not include a lack of capitalization where capitalization was intended?
Well, therein lies the issue, Your Honor.
Right.
The parties here, in the phraseology that they used in their agreement for the definition of term,
right.
It's Article 8, entitled Term and Terminology,
right.
Then subsection 8.1,
right.
That's entitled Term, capital T-E-R-M, underline, that says this agreement shall commence on the effective date, which is a capital defined
right.
term, and shall remain in force for a period of 3 years unless earlier terminated in accordance with Section 8.2.
Right. My question is this. There's a piece of the amendment and the Second Amendment that's repeated verbatim that I think we can all agree is gobbledygook, right? It is not what nobody meant to write those words the way they are. Is that fair?
It's fair that there's a typographical error, but an error is not an ambiguity.
So how do we know that the error there wasn't, that the words that were intended to be put there didn't also include the capitalization of the words E effective and D date?
Because in this case, the Second Amendment, Section 1, the introductory amendment, could not have been clearer. In Section 1, in italicized language, emphasized, deliberate italicized language, it says, quote, unless otherwise defined, capitalized terms used herein shall have the meaning ascribed to them under the agreement.
And so if you let's make it a little bit different.
Sure.
Let's suppose we knew that the language that is, you call it typographical error, was meant to have E effective and D date capitalized in there, in paragraph 2. Let's suppose we assume that. Now, I don't know if that's true, but let's assume that for my hypothetical. Why wouldn't that constitute a redefinition of effective date?
First of all,
under the paragraph you just read me.
Because of the language in paragraph 1, that italicized admonishment where these sophisticated parties are saying, if we're going to change a definition.
One of the things that I find really incredible is these sophisticated parties represented by counsel wrote unintelligible words twice. They repeat, and it's not like this is a 200-page agreement in single space. This is a 2-page agreement worth millions of dollars that nobody bothered to read.
They read it. It has 2 typographical errors, Your Honor, sandwiched in between Section 1, where the parties deliberately stated an admonishment that if we are going to change a capitalized defined term in the agreement, we are expressly going to do it.
Counsel,
yes, there's a typo in paragraph 2, but that doesn't implicate paragraph 1. Yes, Your Honor.
Does the record tell us who drafted the First Amendment and the Second Amendment?
It does not.
Okay,
and
thank you.
In the context of this case, it really doesn't make a difference because it is indisputable that we're dealing with sophisticated parties. The plaintiff, by its complaint, is referring multi-million-dollar deals on behalf of, and this is Exhibit A to the referral agreement, its clients. Plaintiff's clients include MSG, Madison Square Garden, the New York City Transit Authority, stadiums in Texas, California, and otherwise. These are sophisticated parties. Yes,
So
there is a
again,
typo
so
in paragraph
counsel,
2. But
again, like the Chief Judge said, if they are so sophisticated, couldn't it be expected that they would, with precision, go through the contract and make sure that it was as it was supposed to be represented?
what these parties did do in Section 1 in that admonition in italicized language was make very clear that if we are changing a capitalized defined term, we are going to so state it. Yes, there is an error in that one clause in Section 2, but that is sandwiched in between Section 1 that has the expressed admonition and Section 6, which makes it very clear, unless there is a change in the amendment, the referral agreement controls. So there could be no dispute over what the import of paragraph 1 meant.
Clarify,
Yes.
just to clarify, then what is your understanding, because you keep referring to the typographical error, of what 2 must mean? How exactly it should read? Because that's the only way you're going to win on the motion.
And
There
that,
can be no other reading.
right, and that's
So what is that reading?
Justice Friedman,
I know, I'm asking you,
Yeah,
what is the reading?
I read it the way Justice Friedman read,
Go
like
ahead, what is that
everybody else.
reading?
That is the start date that you take the new
No,
Exhibit
you're not
B.
helping me. Is your
Yes.
point you cross out the gobbledygook, or you do something else?
You can look at it. You can take the word "the" out, or you can consider the word "the" with the "with," and all it says is that that's the start point when you take the new Exhibit B and you replace the old Exhibit B into it.
Okay,
It
so you're
does
not, you're still, I'm sorry,
Yeah.
Halligan, I'm sorry, I just need to clarify this. I just want to understand what you say is the only possible reading of 2. Is it, each of the undersigned hereby agrees that, as of the date hereof? Is it that you would cross out the with effect?
You could even keep the in there because it doesn't change the
That
import.
the of the?
It doesn't change the import of that phrase. Now, when you're looking at
Yeah,
a
but that's
contract,
the point. If you can have all these different readings, how are you going to succeed on the motion?
because it's only one clause. If you look at that clause myopically,
Seems to have
outside
meaning.
of the scope of the rest of the agreement, and ignore the admonishment in paragraph 1, where the parties say very clearly, if we're going to change a capitalized defined term, we're going to say so.
How do we know that the thing you're calling a typographical error isn't actually a botched attempt to change the definition as provided for in paragraph 1?
Because the parties said in the prior paragraph, the admonition, if we're going to change a capitalized defined term, we're going to do it.
I
So what-
understand that, but how do we know that that's not exactly what they tried to do and they messed it up?
Because when parties say something like this, it was clear that they
Parties don't usually
contemplated.
say something like this.
Well, if you look at paragraph 1 and that italicized admonishment,
like
there's no
what's in
question that
paragraph
the
2,
parties
counsel.
considered what to do about the capitalized defined terms in the referral agreement. So the fact that in the very next paragraph, notwithstanding the gobbledygook, the extraneous "the," and the common replacement of the "a" for the "e," you look at the agreement in total. You look at that warning in paragraph 1. You look at the agreement in its context. There's nothing in paragraph 2 or paragraph 3 or anything else that indicates any intent by the parties to change the definitions, the capitalized defined terms. If that italicized admonishment was not included in paragraph 1, then I think I'd have a more difficult argument for you, Your Honors. But because of that admonishment, and because the rest of the agreement uses the capitalized defined term, capital TERM, that means that that defined term in the referral agreement in Article 8, subsection 1, applies. You can't have it any other way. What the majority did was take that one clause with the extraneous "the" and the "a" instead of the "e" and imposed a capitalized defined term, an amendment to a capitalized defined term. That you can't do, because in the context of the agreement, the parties expressly conceded that if we're going to change a capitalized defined term, we're going to so state. For the majority to then interpret a typo and say, we're going to put it as a reasonable interpretation, the parties must have meant to redefine
So couldn't
either
one
effective
argue,
date or term.
Counselor?
That's too far of a stretch.
Counselor, so couldn't one argue that since there were two interpretations, neither interpretation should have been done in the first instance, whether you call it typographical or not?
The reason I don't agree with that is because what the court looks at is not any interpretation, it's any reasonable interpretation. And the
Would an
court,
absurd result have occurred with one interpretation or the other here?
well, certainly if the court is going to judicially change a capitalized defined term, notwithstanding the admonishment of the parties in Section 1, that's beyond what a court can judicially
I
do.
think Justice Troutman is asking something different.
Sure.
Are you arguing, I guess, from a business perspective, that the reading that you don't like is one that would have been nonsensical?
Correct.
That's what she's asking.
Yes, the reading that the majority is doing is not a reasonable interpretation.
Why?
What makes it unreasonable?
Because the court then is redefining a capitalized
respect,
defined
not
I
term.
think the question, let me try. I think the question is, if we read it the way they want to read it, forget the language for now. If the contract means that, is that absurd in terms of your business arrangement?
If you read it the way it's written, not at all, because all it means is, no, I'm sorry if I'm mishearing you. If you read it the way the court did, if you change the capitalized defined
Get
term.
to changing the language as a business matter.
Right.
If you read it that way, does that give you an absurd business effect? Is it absurd to read that type of term into this type of business arrangement? Forget the language.
Absolutely not. The phraseology in paragraph 2, on its face, even with the extraneous the and the misspelling of the A, only indicates that that's the start date
You
of
missed
the
the
Second
forget the
Amendment.
language part of my question, right? So would the reading, I'm sorry, one more time. Forget the language of this contract. Would the reading that your opponent wants to give this language result in an absurd business relationship?
It would change the parties' agreement, which is an absurd thing because the parties expressly agreed that if they were going to change the definition of term defined in the agreement, they were going to say so specifically, and they didn't do that.
Thank you,
So to
Counsel.
take that, to take the way the majority has taken the provision and the way that the plaintiff interprets it, yes, it's absurd because you're creating
Your
a
red
new
light is
definition.
on, Counsel. Thank you. You have your rebuttal.
Thank you so much, Your Honor.
Good afternoon, may it please the court. Christoph Heisenberg for the respondent. In this case, we certainly agree with the assertion that the language is gobbledygook.
But
And
counsel, let's go to that for a second, and maybe to get back to something the Chief Judge was asking your opposing counsel. If we look at this, which clearly seems to me a garble in the language, to me an ambiguity to be relevant legally has to be, I think this term means X, you think it means Y. The ambiguity gives you room to say it's either X or it's Y. And I'm having trouble understanding how this garble, ambiguous as it may be in an abstract sense, gives you a possible reading the way you want it.
sure, there are 4 reasons for that. Fundamentally, I think one thing that was not addressed is that the argument about what the definition means and that would support his case isn't true. The definition of the word term that the parties adopted is simply a period of 3 years. It does not include the first component of that sentence, which says the original agreement's effective date, which is where his defined term comes in.
But is effective date a capitalized term?
It is, but it's a compound sentence, compound predicate. That element is not part of the definition in 8.2. When you look at the definition in 8.2, using a standard rule of grammar called the rule of the last antecedent, or the nearest reasonable referent that this court has used, it is the item that comes right before the definition. And in 8.2, that is a period of 3 years only. The more remote part of that sentence, which includes the effective date, is not part of that
So in
defined
the
term.
original agreement, forget the amendments for a second, effective date means what?
The effective date, as capitalized in the original agreement, is simply when that original agreement becomes effective, not to.
Which is a date certain.
A date certain. However, the defined term, the capital T, is simply a period of 3 years, and it's conditioned, or its impact is conditioned on when something starts.
Yeah, but none, the rest of the contract didn't say anything about that. Aren't you really creating your own 3-year term without explicitly saying so?
No. So again, I referred to the rule of the last antecedent. When you look at what the term is, it's 3 years. However, there's also several
But doesn't that ignore that effective date is itself a capitalized term?
No, it excludes from the definition of term any effective date. In other words, the 3-year period of term was left to be contextual, just like a presidential term is 4 years. However, President Bush's 4 years starts at a different time than.
But doesn't the definition itself, I'm looking at 8.1 from the referral agreement, doesn't the definition of term tether it, maybe you're saying the last antecedent rule helps you get out of this box, but I'm not sure I see how. It tethers the term not just to 3 years, as you say, but it commences on the effective date. So isn't it the effective date, which is a defined capitalized term, which I think is November 23rd of 17, plus 3?
I think Your Honor has put her finger on it, which is that it is not tethered to the first part of that sentence.
Why not?
The rule of the last antecedent speaks to this. It says when there are several things in a sentence, the definition is only of the thing that precedes
The
it
3 years
immediately.
has to be anchored to something, right? It's 3 years from X. And it seems to me that the most natural reading, let's set to the side the gobbledygook and whether that introduces sufficient ambiguity to help you, but 3 years is not free-floating, it's 3 years from X. And so I don't see how last antecedent does the work you think it can do here.
Well, I think that's the very point here, is it was intended to be a floating term because it's used in several contexts. If you look at the third sentence of this, it refers to a transaction having a term and this agreement having a term, meaning that there were going to be different starting points, and the third sentence specifically was negotiated to address the situation in which there is a transaction which has a 3-year term that exceeds the original agreement's 3-year
So if we
term.
disagree with you that the last antecedent rule achieves that, then do you lose? Do you have to prevail on that point?
No, because this third sentence distinguishes between a transactions term and,
I guess I didn't phrase my question very well. If we disagree with your parsing of 8.1, do you lose, or are you also arguing that the gobbledygook, to use perhaps appropriate term, independently allows you to proceed here?
it does, because there is language in the amendment which says that it would have effect as of that point, notwithstanding anything to the contrary in the original agreement. That is standard language that would override.
And that effect is to change the effective date of the underlying agreement?
No, and this is why, when we were talking about a floating term, the original agreement would still be in place. However, the transactions under it have their own starting point.
So why do you need the ambiguity? Wouldn't that
We don't believe what we do. We think it's a rather straightforward.
So your argument is really the way the original agreement is written, this isn't subject to what are the specific terms and effective date of the original agreement.
Correct, that the original agreement specifically contemplated that there would be follow-on transactions that would have their own starting points, and that therefore, the 3 years of those transactions would exceed the original agreement's
So
starting point.
essentially, I'm sorry, just so I understand, the qualified transactions, by virtue of, I think, the third sentence of 8.1, have their own terms,
Yes.
essentially.
And that was specifically negotiated. Now that we've had discovery, the benefit of discovery, what was referred to in the last, why this was included, was that each transaction would have its own 3-year window. And my client pointed out to their client that because those would naturally come later on, once the clients were approved, those would extend past the original agreement's term, and that in those circumstances, the transaction's 3-year term should supersede the original agreement's.
I take that argument, but let's say that, and I understand it now, but let's say that we would disagree with that, and we say, okay, effective date means 3 years from that original date. How would this ambiguity change that?
I'm not sure I fully
How
captured.
can you fit your view? All right, we're going to assume 8.1 means effective date is 3 years from, the term is 3 years from that effective date, which was November 2017, whatever it was. Now you want to read this amendment and this ambiguity to change that effective date. And again, putting aside your argument that you don't need to change it, but if you did, how could you read this garble, this ambiguity, to support the parties, particularly given the italicized language right before, to support the argument that, because even if you read capitalization in there, you just read that as the original term, unless you've specifically changed it. So the fact that effect may be effective and date may be capitalized just gets you the original term. And if we're not reading the original term the way you're reading it, that's 3 years from November 2017.
However, the gobbledygook sentence continues on that specifically says, notwithstanding anything to the contrary in the
Right,
agreement.
but this still has to change something that means notwithstanding anything. You think that that means you don't have to comply with, if we really want to change an italicized term, we have to make that clear. You can just use a new italicized term as a notwithstanding anything in the original agreement.
No. However, given that the language here is, the very impact of it is to set a new starting point for when the amendment
You
comes
say
in.
that, but how am I reading that in this language? How am I reading, if we assume effective date term means not what you say, but something else, how can we read this language any way to indicate that they've changed that? They've
The
agreed
intent-
to change.
The intent and the purpose of this language, which also the evidentiary record comes in.
Tied to what is actually on this page.
Yes, and the last bit that I would add here is that the parties that drafted this and know it best, the practical construction that they placed on it is that this would extend the payment obligations of this into 2021. There was an admission by their CEO.
We don't really have this in our record, though, right?
Well, it is in the complaint that their president, CEO, in late 2020, told my client that she would be paid upon this transaction in 2021.
But are we considering here that sort of extrinsic evidence, or just what's on the four corners of these agreements?
Well, so in the event to show.
Because I would think it
whether-
would be the
To
latter.
show whether there is an ambiguity, you can see what the parties intended and look at extrinsic evidence for that purpose, I would submit. So obviously, if you find that it is, completely clear and there's absolutely no ambiguity in this agreement, then the ordinary rules would exclude that.
To return to Judge Garcia's question, if I can, just so I'm clear, are you arguing that the gobbledygook in the Second Amendment, also in the First Amendment, has some effect and introduces some ambiguity? or are you relying only on whatever extrinsic evidence you say is referenced in the complaint? I understand you're also making an argument about 8.1 and the effective date, but if we set that to the side.
Right. So I'm not sure I fully understood what we're setting aside and not.
Sorry,
but-
let me try to be clearer. If we were to disagree with you on your reading of 8.1 and the last antecedent rule and the third sentence, and we were to focus instead on the gobbledygook and what impact the gobbledygook has on the obligations and the term of the contract, are you arguing that it has some independent effect aside from your 8.1 argument, or no?
Yes, we certainly agree with the analysis of both Supreme Court and the Appellate Division. That is, that this is more than just a typographical error. This was poorly written, drafted language by their attorney.
It was intended to do what?
And it was intended to create a new starting point because this was a brand-new transaction. This was the earlier agreement related to the sale of services and goods. This was a brand-new creation of duties with
But for us
respect to
to get there,
investors.
don't we have to add terms to this contract that aren't there?
I don't believe.
I don't see how we get there. And is it significant at all that that part of the contract that we're calling gobbledygook was in the preamble to the Second Amendment? It's not even in the portion that requires us to look if we're looking for amendments to it in the referral agreement. Is there any significance to that?
I don't believe it is, because the purpose of having a new effective date is as to when the obligations are created and from when that they would extend 3 years into the future.
And so the way that I had understood the Appellate Division majority's alternative, we want to call it, possible interpretation of this language, was that it might have been meant to read that with the effective date hereof, and that effective date might have been capitalized, and that if people had written it the way they wanted to, and then that would have meant there's a new effective date hereof, right?
Yes.
As of this date.
And I think that's the
That's
most.
how I understood their alternative argument.
And I think that is exactly how one would interpret the.
Well, maybe not.
Counsel, I mean,
Well, how is that, I want to get to a point I think I understood he was making. Why wouldn't that be nonsensical? And why wouldn't perhaps the more logical read be that the problem isn't all these words? It's not really gobbledygook. The problem is the word "the." It's one additional word that throws everything else into confusion. And you would read it as, agrees that with effect as of the date hereof. It may not sound grammatically beautiful, but you get the point, which is different from saying, well, the whole problem is you've got the with effect, and that whole thing sounds strange, because then you really are changing effect into something else. You're changing with effect into something else.
I think it's still lacking a noun, and so it's not just excluding the word "the" as an extraneous word. It really has to be that this amendment, and it's lacking the word amendment in there. But
I don't understand. At the end, you've got shall be amended as. Each of the undersigned hereby agrees that, that with effect as of the date hereof, and notwithstanding anything to the contrary in the agreement shall be amended as follows. And then you've got whatever they
yes,
claim to have agreed that they are amending.
and it's the with effect as of the date hereof needs to be to be tethered to a noun. What is the thing that has effect as of the date thereof, and that is this amendment.
But counsel, I'm sorry, may I ask? What did this, just generally, what did this amendment do?
So the initial agreement addressed getting payment for referring customers.
Right.
This amendment suddenly converts a new set of obligations. That is, if someone wants to invest in the company, you're also entitled to a fee. So this created a brand-new scope of payment rights.
And isn't that kind of, it seems to me, what the purpose of with effect of the date hereof would be? They're not going to do this retroactively for the term that's already expired. they're going to have these new obligations prospectively for whatever's left.
Not quite, because the introduction had already taken place. What happened was a customer had not only said, I'm interested in this as a product, but I'd like to invest in your company.
When you say introduction, do you mean an introduction for an equity investment or an introduction for one of the, whatever was contemplated in the original agreement? I think you call them referrals or something.
Right, it was a referral for buying the product, but during the course of that referral, the customer, potential customer said, this sounds like a great product, can I invest? So the introduction had already occurred, this
Okay.
was to.
And my understanding is that both amendments covered the compensation structure for the equity investments, not for the referrals that were under the original agreement.
Correct, those remained, which is why, again, the point of why you had to keep the original effective date in place for that, or the original services. However, you're creating a new time frame for these new obligations.
Okay, so then why would you need to even, to the extent that you're arguing that paragraphs, Amendment 2, Paragraph 2, with the gobbledygook paragraph, changes the effective date of the referral agreement, why would that even be a necessity if there's a different set of rules in place for equity investments versus product referrals?
And we don't believe that it was changing changing the effective date for the original services. It's creating a new starting date for the new term, 3-year period.
But wouldn't that be an argument in support of what Judge Rivera just said, which I think is something like that with effect as of the date hereof, and notwithstanding anything to the contrary, et cetera, et cetera? That would seem to be the most reasonable reading if that's the way you view the distinction between the referral agreement and these amendments.
And they're starting a new starting date for a 3-year period for these new services, was the intent. And I believe it follows from the words, which is that if term is simply a 3-year period, this is simply creating a new starting point for these new services going forward. It does not change the 3-year period for the prior services, and that was.
If I may, I just want to make sure I understand a response to some of the questions with respect to the purpose of this amendment. So if I'm understanding you correctly, you're saying it's, in a way, resetting the clock of the term period, but it would apply to investments prior to the new 3-year clock? Or only prospective, which I think was Judge Garcia's point in this?
It changed the first amendment.
Yes,
Was to capture the prior introduction.
okay.
When they breached that first amendment by not paying, the second novation effectively wiped out the First Amendment. This
Okay.
then creates a new starting point for the new services going forward, because it's not just with respect to the one
That's what I mean. So then
investment.
it is this equity interest moving forward as opposed to where someone may have shown an interest in the past.
Yes, it's a 3-year period.
So
creating-
again, I don't understand why, if you just take out the word "the," he's not right.
Oh, I mean, I certainly think that was the intent. What I was pointing out is that the statement of saying that.
Well, if that's the intent, why are we talking about it might be effective instead of
Well, because-
affective, and it's a capital E? I'm not understanding
Because
this
the
argument.
appellate division
Yes.
took a different tact of finding an ambiguity.
Yes,
To our view, the rule of the last antecedent says the term is simply a 3-year period, and
Yes.
for the original agreement, it
Yes.
starts from then.
Yes, sir.
However, for this new set of services,
yes.
there's a new starting point, and you don't change the
But
earlier.
are you disavowing the appellate division's approach or not? That's what I'm not clear I'm getting an answer from.
We think it was unnecessary because we think the
I
language
appreciate that, but
follows.
do you think that, are you adopting it? Are you asking us to adopt it, or are you relying solely on the last antecedent?
We're not relying solely. Obviously, we believe that the analysis by the appellate division was also correct. However, we don't think you need to get there.
Thank you.
Thank you.
Thank you very much. Just picking up on this concept that you heard, that the capital defined effective date is not part of the capital defined term in section 8.1 of the agreement. Nothing could be further from what is written on the page. 8.1, page 195 of the record, starts with the word capital term, capital TERM, underline. It then says, quote, "This agreement shall commence on the effective date, initialize, capitalize, effective date, and shall remain in force for a period of 3 years unless earlier terminated in accordance with section 8.2, paren, quote, bold, inishcap term." It then says, significantly, the term, singular, capital TERM, the defined term tethered to the defined effective date of November 23rd, 2017, may be extended. That's the word used, by the written agreement of both parties, end quote. What counsel is trying to say, to create even more of a gobbledygook, is that we should ignore that completely, and that notwithstanding the admonition in italicized in section 1 of the Second Amendment, that the word extended is irrelevant, the singularity of the word term is irrelevant, and somehow, some way, we can redefine ordinary words, date and effect, to create a new definition. That's just not there. I understand that counsel is now not really arguing what the majority argued, but what they did was that they looked myopically just at this one paragraph with the extraneous "the" and created a new definition which isn't there. Because as you pointed out, Your Honor, the second paragraph of the Second Amendment says the agreement is amended as follows, colon, and what follows is paragraph 3. Paragraph 3 makes clear it is the replacement Exhibit B, and the only reference to any defined term is the word, singular word, capital TERM, meaning additional equity transactions within the term. This was not a standalone agreement, as counsel stated. This is the Second Amendment. The First Amendment had already been executed. This is the Second Amendment, which deliberately spoke to additional, quote unquote, additional investment transactions within the defined term, which is defined clearly in the agreement as starting on the defined effective date, November 23rd, 2017, and lasting 3 years. There was no amendment to that, and for the court to implicitly create a new capitalized defined term, notwithstanding the admonition in the italices in paragraph 1, makes no sense, because paragraph 2, as Your Honor points out, can be read even with the extraneous "the" as not being absurd. It just means this is the day we're taking out the old Exhibit B from Amendment 1 and putting in the new one. And any additional equity investment within the capitalized term will result in an additional bid.
Thank you.
Thank you very much, Your Honors.